Okay. Are you ready for me to do the housekeeping?
Absolutely. And then
Okay.
roll call.
All right. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Rules Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference meeting and to please be aware of your surroundings behind you. All Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select enable auto transcript. Thank you.
Thank you, Kim. Okay, would you take the roll call?
Alikani? Al-Saraf?
Here.
Blakemore? Here. Campbell?
Here.
Connolly? Galkin?
Here.
Stanville?
Here.
Milrod?
Here.
6 present, we have quorum, 2 absent. And our liaisons, I see Melanie, Laura. I know Selena's on vacation and I don't see Lauren. Okay, and then we have State Bar staff. Okay, so I'll turn it back over to you, Patience.
Thank you. First, is there any public comment? Is anybody queued up to speak?
No one has their hand raised.
And the agenda that went out did not include approval of the March 20th minutes. And I'm wondering if those are available or how should we deal with that?
Oh, I apologize. We did not notice that, so we will not be able to vote on that. So maybe the operations team, can you guys remember to agendize that next time? Because there was one, we couldn't vote on it last time. We forgot to agendize it, Patience, we apologize.
I just didn't want to lose track. Great, well then, item 3.1 or 3, the only item 3 is approval of the May 7th meeting minutes. Hi, Jacqueline. So do I have a motion to approve them?
Catherine will move.
Thank you. Is there a second?
I'll second. Vanetta.
Okay.
Thank you. All right, moved, seconded. Any discussion about the May 7th minutes? Hearing none. All those in favor? We don't have to do roll call for this.
I have to do roll call, yeah.
Okay.
Sorry.
Roll call.
Alikani? Alikani, okay, yeah.
Here.
Thank you. Al-Saraf?
Yes.
Blakemore?
Yes.
Campbell?
Yes.
Connolly? Galkin?
Yes.
Stanville?
Yes.
Milrod?
Yes.
7 yes, 0 no's, motion passes.
Thank you. So the other item on the agenda is the substantive item, and Jennifer, I think this is yours.
Yes, this is, Jennifer and Jacqueline are gonna be presenting on this.
Excellent, thank you. Take it away.
Oh, Jennifer, we can't hear you.
Can you hear me now?
Yes.
When I shared my screen, could you see the full screen version or the version with the notes? I'm sorry about that.
I didn't catch that, sorry, I was looking down, Jennifer.
Okay. Just a second. Thank you for bearing with me. Okay. Hopefully you're able to see that.
You see it without the notes, you're good.
Wonderful. Okay. Um, with apologies for the technical difficulties, this is agenda item 4.1 to approve recommendations regarding program quality controls and non-compliance requirements. The working group consisted of Jacqueline, Alikani, Erica Connolly, and Diana Cruz. My name is Jennifer Zelnick. I'm a lead program analyst in the Office of Access and Inclusion, and I'm happy to co-present today with Jacqueline. So just very briefly, before we get started, we wanted to acknowledge that we saw the public comment that was submitted in writing. Staff has discussed this internally with the Office of General Counsel, and there's no legal concern. Briefly, I'll address a few points. Regarding concerns about due process, Business and Professions Code 6224 does cover the appeals mechanism for organizations, or I'm sorry, for applicants who are either denied funding or required to return funds. And additionally, the government code that was referenced actually does not apply in this instance because it was not incorporated into the State Bar Act. So I think that covers it pretty much. The rules are not unclear. We looked again carefully at our recommendations and stand by what we're going to recommend today. Are there any questions about that before I move on?
Yes, I didn't see that public comment. I saw LAC's letter, which was attached.
Shannon, can you re-forward it to?
Yes, I'm forwarding it now. I was just noting patients, I didn't receive it either, so I don't, maybe we don't know who it was from or
Okay.
anything, so.
So we'll resend it right now. Guarantee.
Yes. Is it helpful if I give everyone a minute to look at the public comment, or should I move forward?
I think you can go forward, and if there's other questions later.
Great.
It's fairly short, yeah. I think just forward it on.
Thank you. Okay, so we're going to, for our agenda, talk about quality controls and non-compliance codification topics, governing authorities, guidance, and current practices, the stakeholder inclusive process, the proposed rule revisions, and then the proposed resolution. So for the next section, I'll turn things over to Jacqueline. And Jacqueline, please let me know when you'd like me to advance the slides.
Jacqueline, you're muted.
Sorry about that. Okay, so now for the quality controls and non-compliance codification topics. Please advance. So these topics are: how should the rules define quality controls? What quality controls are required for the trust fund program grant recipients? What should be the procedures for state bar staff and the Legal Services Trust Fund Commission to address grant recipient noncompliance? And what actions should be available to the LSTFC when faced with severe, recurring, or unresolved noncompliance? Next slide.
Thanks, Jacqueline. So I'll discuss this section on the governing authorities, guidance, and current practice. So first we'll talk about the IOLTA statute. Per Business and Professions Code 6213, QLSPs are required to have quality controls. They specifically use the language of quality control procedures approved by the State Bar of California. Similarly, Business and Professions Code Section 6215 stipulates that support centers are required to meet quality control standards unless they are legacy programs as defined in 6215 subsection A. Business and Professions Code 6217 requires the maintenance of quality service and professional standards for all grantees. And just as a note, that although these phrases are slightly different, they encompass the same idea that we're talking about quality controls. Next, we have Business and Professions Code Section 6224, which I referenced previously. This section lays out procedures related to determinations of not qualifying for funding or terminating funding because of noncompliance. This section allows the State Bar to determine that an applicant is not qualifying or deny future funding and terminate existing funding because of noncompliance. And it also delineates the appeal process for applicants to contest denial of funding related to noncompliance. However, it does not specify how the Legal Services Trust Fund Commission should address noncompliance, which is something that we wanted to accomplish with this codification topic. Now we'll move on to State Bar rules. Rule 3.661, Section C states that the current ABA standards are the guidelines used by the Commission to approve quality control procedures. And we'll talk more about what those standards look like in a little bit. Next, we have Rule 3.680, subsection E, Section E, subsection 2, which explains that information about quality control and review procedures are a requirement for all grantees for QLSPs and support centers on the IOLTA application. Rule 3.681 requires grantees to annually submit information describing how they maintain quality service, professional standards, and compliance with program requirements. Again, though quality control as a phrase is not used, quality services and professional standards are deeply related. Moving on to the general grant provisions. As this slide demonstrates, both QLSPs and support centers are required to have quality control procedures adopted by the State Bar. Our office is moving away from the eligibility guidelines, but I wanted to bring them up here to note that the guidelines do again address that the ABA standards for the provision of civil legal aid are the quality control standards for the Commission. They also stipulate that if an organization is already subject to quality control review by the Legal Services Corporation or the California Department of Aging, grantees are required to describe those quality control procedures. Next, I wanted to talk briefly about the ABA standards. Overall, the standards provide lots of guidance on quality controls. However, this isn't really a how-to guide, and the standards do not provide a definition of quality controls. The foreword states that the standards have been and continue to be widely referred to and relied upon as aspirational guidelines. Each section can lend itself to quality controls. At the same time, nowhere in the standards do we actually see the phrase quality controls ever used. So that's just something to keep in mind. Although we point to the ABA standards in Rule 3.661 and as the guidelines that the Commission should use for quality controls, it's not entirely practical or actionable because this is a 300 page document. So again, with this codification topic, we wanted to provide some additional guidance. Okay, so now I want to talk about current practices, and we'll start with quality controls. Grantees and applicants are required to answer a series of questions for review annually as part of the IOLTA EAF application process. These are found on the Quality Control Review Form, which is Form 5, the Staffing and Volunteers Form, which is Form 3, the Certifications and Assurances Form, which is 9, and the Organizational Profile Documents. The annual IOLTA EAF budget review process also includes quality control questions, specifically on Form C about compliance assurance. And importantly, our office regularly conducts monitoring visits with grantees to determine whether they are in compliance with the IOLTA statute, state bar rules, grant provisions, and the ABA standards. And as you all know, these visits are conducted normally on a triennial basis or sooner as needed. And this really provides staff with an opportunity to see some of the quality controls put in place. Okay, next we wanted to talk about the current practice for noncompliance. The commission and respective committees review quality control and related noncompliance concerns on an ad hoc basis and make recommendations to take action as appropriate. Eligibility specific concerns for the IOLTA and EAF application are reviewed by an eligibility and budget review committee working group at an eligibility review conference, or ERC. The ERC working group then makes recommendations to EBR, who finally makes recommendations for approval by the Legal Services Trust Fund Commission. Now I'm going to turn things back over to Jacqueline to talk about our next section.
Yes, so now we'll talk about the stakeholder inclusive process. Next slide. So the working group researched and drafted rule revisions. We met and discussed all of these issues. It reviewed input from a grantee feedback session, and all of the grantees were invited. 20 grantees actually attended. And the working group circulated the draft memo via Legal Aid Association of California for 3 weeks. And the community responses were as follows: generally supported more transparency on grantee requirements to demonstrate adequate quality controls and grant compliance, as well as the escalation of the consequences for non-compliance. We requested, clarification was requested and additional materials about several topics, made some requests outside the scope of quality controls and non-compliance codification. Next slide. Requested templates or examples of policies and procedures. The staff plan to develop templates for the reporting handbook as part of codification implementation. Requested clarification about the difference between a policy and a procedure, and a policy refers to the guidelines or rules that an organization enacts, and a procedure refers to the steps an organization takes to implement the policy. So for example, an organization may have a performance evaluation policy that all employees are evaluated annually. And such an employee performance evaluation procedure may include the following steps: a simultaneous self-evaluation by the employee, and evaluation by the employee's supervisor, a meeting between the employee and supervisor to discuss the evaluations, and entering the supervisor's evaluation signed by both parties into the employee's personnel file. Next slide. Requested an explanation about why each document is required and how it relates to compliance. So although the draft memo contained this information, the working group created Table 1 to further clarify each of the proposed requirements. And you can see the recommended requirements here to demonstrate quality controls. The requirement, appropriate organizational infrastructure that ensures adequate governance and oversight and complies with applicable laws, regulations, and ordinances, including requisite business, legal, and financial registrations and licenses. And the rationale being that requiring requisite registrations, licenses, and policies will help ensure that grantees remain in good standing as a nonprofit. And our current practice is that grantees must already maintain requisite registration, licenses, and policies on the State Bar's management, platform. Next slide. Requested examples, hypothetical or real, of when a board would be notified or when a grantee might be debarred or lose funding. So these examples are the working group specified that the LSTFC would notify an organization's board of directors when a grantee experiences serious quality control issues or when it has significant difficulties managing the program. The working group also clarified that the proposed rule revisions use of the word debar would mean that an organization's status as a state bar grant recipient would be rescinded, not that their attorney license would be revoked. The working group noted that debarring or defunding an organization is different and much more serious than disallowing costs. Next slide. Requests that are outside the scope of quality controls and noncompliance codification. So this includes a clarification about whether grantees who were asked to share employee I-9s could redact personal information, greater transparency and predictability around deadlines and extensions, more information surrounding monitoring visits and staff response times, specifically for the HP3 desk review. Next slide.
I think that's it for this section, but if I can just provide a little bit more information on this last slide, if that's okay with you, Jacqueline.
Yes.
Thanks. So just to clarify about these points, we briefly addressed all of these in the memo. Specifically, excuse me, that grantees should always redact sensitive information, and that Rule 3.680F and staff's codification implementation efforts address concerns about deadlines and extensions. More specifically, Rule 3.680E subsection 1 addresses deadlines and extensions for the audit. And finally, that staff does agree to more transparency and timely communication about monitoring visits and staff response times generally. Okay, so now, if there are no questions up to this point, we can move on to the proposed rule revisions. Let me try to pull this up as a Word document. Can you all see the proposed rule revisions now?
Yes.
Excellent. Okay, so again, this is changes to Rule 3.661, duties of the Legal Services Trust Fund Commission. As you can see, subsections A and B are unchanged. And then what we have proposed is inserting the definition of quality control standards and procedures into subsection C, along with, the requirements for these standards. Would you like me to read this or leave it up on the screen for a
Oh,
moment?
no, please don't.
Wonderful,
we
thank
all
you.
got it ahead of time. I'm assuming we all read it.
Wonderful.
I wonder if this is a good time for some questions.
Sure.
I thank you, Dwan, for circulating the
Yeah, no, we apologize for that. It was an
public
oversight.
comment. I appreciated it. I found that it echoed some of the concerns that I had. And so I just want to explore this a little bit. And what I emphatically don't want to do is relitigate anything that the committee already thought about, talked about, considered. So Jacqueline and others who were on the subcommittee that addressed this, please put a sock in my mouth if I'm going on and on about something you already thought about. But the concerns are that certainly the changes in the rule offer a little bit of additional detail, but the crucial questions like what's adequate supervision, what is workload, how do you manage people's workload? I looked at this and I thought, oh my gosh, when I was in ED, there's like 6 of the 10 things that I'd be going, not because we're not trying like the Dickens, but because it's just, there's always more work to do and can possibly be done. And you have lawyers who haven't had any training, but and being managers, but they are stepping into management roles and bless their hearts because someone has left to go somewhere else that pays them better, whatever. All those things that are part of the real world trying to make sure clients get served with staff that often is just learning either how to be a lawyer or just learning how to be a manager. We had the whole time I was there after we fired our incompetent CFO, then the rest of the time, the remaining 4.5 years, we had a contract person. So who was of necessity not totally under our management, and this one got beautifully. But so there are a lot of spaces for discretion, exercise of discretion by staff and by the commission. And I could see why CCWRO, they have special reasons to be nervous, but I think what we're offering when we say we're going to codify these practices is greater specificities. People know, like, what do I absolutely have to make sure is absolutely done? Of course, there's thousands of those things. Anyway, just a law firm, there's a lot to make sure you're doing so that you're not malpracticing things. So I wonder if it's possible to add, or have you already all discussed the question? What do you mean by organizational infrastructure? How do you define that in a useful way for the grantee? That I hope this is. I know I've gone on and on. Is there those of you who are on this subcommittee on the work group? I would really love to hear from you about how it was that you thought about these things. It's guidance for the grantee, really.
I could take a stab at that while maybe Jennifer or Jacqueline, if you want to jump in, because I participated in these working group meetings. This is Dawn, by the way. So the working group did contemplate being more specific, but it was really hard. But I think you give a good example that maybe the organizational infrastructure could have maybe a greater definition. But the other, what I think they wrestled with the supervision, because as you all know, like depending on the area of law, the organization, it's hard to be really prescriptive on that. I mean, I think they did contemplate on being really specific in terms of like attorney or managing attorney versus like other staff supervision, but it was very hard to be that descriptive and prescriptive. And so I think for the supervision piece, they moved away from giving like a hard and fast like ratio and more towards this is what you need to think about when you are like thinking about attorney supervision and the infrastructure of your organization. And there was a lot of back and forth and like where to be more specific and where not. And, you know, this is one of those topics that we worked very closely with OGC, and the recommendation was to keep at this kind of level. But organization infrastructure, I could see that where that could be, maybe we could have more details on that. I don't know if you can for each one of these though. That's my impression from being in those working group meetings. But Jennifer, Jacqueline, and Erica Khan is not here. She might come later on, but she's a part of that working group too. And I think there was one more member, right, Jennifer, from the working group?
That's true. Diana Cruz was also a working group member, but she's not a member of the Rules Committee, and I don't believe she's here today either. Jacqueline, did you want to address those comments, and then I'll go after you?
Well, you know, as Don mentioned, we did go back and forth quite a lot on a lot of the detailed issues. And it's, you know, I think it gets sort of complex when it comes to detailing out, you know, for these kind of requirements for many different organizations that have you know, varying different organizational structures and focuses. So I'm not sure exactly about how much discussion was done about this in the past, but we did try to address this issue, and as Don also mentioned, that, you know, meetings with the OGC took place, and this is what we came up with. But, you know, I think we're open to any areas that you think need to be redressed.
And I'll just add to that, if I may, in terms of organizational infrastructure, I think that if that phrase is a problem, we could also very easily perhaps remove it from that bullet point. But the way that we understood organizational infrastructure to mean is just the systems and processes that are required to run the organization. So we could also add that to the memo if that clarification is helpful. And I also wanted to make another point that by and large, the requirements that are laid out in this proposed rule revision are not new. It's simply codifying in one place the current practices that the staff and the commission already employ, which is something that we really emphasized to grantees during the feedback session that Jacqueline mentioned that we had in March. So again, we're not trying to add new requirements. We're not trying to create processes to make things more difficult for current or future grantees. We just want to make sure that when issues arise, it's very clear what needs to be done in order to be or to become compliant.
This is Catherine. Whenever I can't, we just see the document really, and Jennifer. So whenever there's a moment, I have a couple of comments as well.
Go ahead.
Okay, thank you. I guess, so the first question is, my recollection when I was at ED is like in those triennial reviews, there was a list of documents that we were required to send the state bar to demonstrate that our services were of sufficient quality. And so I did not have an easy way to go back and compare what was on this list with that list, and it kind of goes to Jennifer's point of, are we codifying kind of the current practice that you need to have policies about how you provide supervision? And those are reviewed as part of that. And if so, I'm probably more comfortable with that because I think we were used to doing that as a grantee. So I'm interested in that. The one area that seems remarkably not specific to me is the financial management. And I don't quite I mean, this is an area where we've actually, at least in eligibility and budget review and other places, been concerned. It just says kind of maintain financial controls. And then the example is submitting an audit, which is already a requirement, or a financial review, but there isn't a requirement that you have policies and procedures, or that policies and procedures for internal control. So to me, that felt like by comparison to the level of detail for every other section, it felt very weak to me. And I thought needed some greater clarity about what are we expecting. And I do think in what you currently require is for grantees to produce is more than what you're codifying. And I guess my last question is, I think we've lost something in the definition of what is quality way back at the top. So we talk about quality and we say the purpose is to protect clients. Well, I actually think quality that's important. And I assume we're talking about protecting clients in the context of receiving those services, but isn't the purpose of quality to ensure that grantees provide effective civil legal services? I mean, that's why we give them money to provide services, and we want to see that they're effective. And I'm just troubled by our focus on the sole purpose of this is protection of clients and not effective delivery of civil legal services. And I actually like incorporating in the definition civil legal services because we've done a lot of work to define what civil legal services are and the breadth of those. And I think it would be a mistake to not, in essence, incorporate that concept into what does quality mean. So those are areas I guess I'm interested in, kind of those three buckets.
Thank you. Does anyone else have other comments? I guess, yes, please.
So 2 comments. One, I think, in reference to the public comment and others, it's not clear to me, and I guess I would have a question to staff or otherwise to fellow commission members, that in the absence of hyper specificity and clarity, why wouldn't a reasonable practitioner standard be applied to some of these things? I mean, they're like I'm just looking at the public comment, and there are some things in here where it's like, well, what do you mean by this or that or the other thing? And I think there are some very clear things that we would be able to say, well, anyone in objective reasonableness would say this is clearly insufficient, right? If we want you to document something, if you have a blank document with a heading that states that rule set, it's clearly insufficient, right? We all know that. The practitioner would know that, right? So now if they had something that we felt didn't go far enough and yet it was lacking clarity, I think that's where we would get into maybe there shouldn't be, a consequence. And I guess that's the due process part of their argument. Like, we haven't gotten there yet. Maybe it should be well, let's have some clarification about this isn't sufficient and this other thing is. But I'm not sure the level of hyper specificity requested even makes sense. It would be too prescriptive, I would imagine, and assume a level of incapacity on these organizations to take reasonable steps responsive to this. The other thing that I relative to the public comment that stuck out to me was concern about staff, which I'm assuming they mean state bar staff interpreting things in different ways and applying different standards. But where I saw that comment, it was in reference to the commission making certain decisions. So I think there's a relevant distinction to be made. Are we talking about staff making those decisions or the commission deciding to direct staff to do something, and the commission is the organization with or the entity making the authority, the decision of authority. And it seems to me that a commission making the decision when it's got the empowerment to do so is not unreasonable. Staff may be different, but staff is who acts on behalf of the commission's direction as opposed to wholly independent. I am concerned though about the lack of an opportunity or an opportunity stated for some relevant steps of due process for the organization to explain their side of the situation, either to the commission or otherwise. Because there are things where, okay, maybe we as commissioners would hear it, and in hearing the explanation, it's like, okay, we can understand how that interpretation might be reasonable. We're not comfortable with you taking that approach going forward, but maybe the consequence isn't, so severe. And it's now that we have more clarity about the reasonable interpretation that was made. And having an opportunity seems like it would be beneficial to everyone involved for a recipient to express that, well, here's kind of the logic behind whatever this decision was in response to the rule set.
Jason, Catherine, to your point, like on page 13 of the memo, and I was a little confused by this, but I think it gets at what you're saying, which is to be approved by the commission, an applicant's quality control standards and procedures must be sufficient to allow the applicant to credibly demonstrate compliance with this. It says statutory requirements. I also think it would be the rules, but so I to me, that's it could be maybe written differently or strengthened a little bit, but kind of goes to the standard of like, you have to show us how you're doing this and allows for flexibility, because I think it's going to depend on the size of the organization, the type of legal work that you're engaging in, right? There's a whole bunch of factors. So I agree with your point. Like, I don't know how to be more specific about like supervision should be, you shouldn't supervise more than five lawyers, but what about the degree of experience of those lawyers, right? Or what about the kind of legal work you're doing? So to me, whether this precise standard on page 13 of the memo is right or could be written slightly differently, I think it gets to the you show us your procedures, you tell us how these meet the standards and the rules, and then there's some judgment that the commission's going to exercise about that. And I agree it should be the commission, but that's kind of the best we can do in a rule, I think, rather than get into it has to be these specific things, which I think a lot of programs would not appreciate. That level of supervision has to look like X or Y, or, anyway.
I think as the memo pointed out, that much of this gets handled with a handbook.
Yeah.
Where there are examples, and there are, because I agree with you, I mean, frankly, I would have been one of those people who would have liable to being told, now you move your right foot, now you move your left foot, cross your T, dot your I. So, but let me just be sure and I want to be sure that people have a chance to say whatever they need to say. But right now, what we have is not the order in which they were raised. Jason mentioned an absence of due process specifics.
Yeah.
You mentioned concern about financial controls and incorporating the civil legal services definition into the quality control concept. And then you had a third one, and I didn't catch it.
Yeah, I talked about ensuring that the goal of this is to provide effective legal services, right? Civil legal services, anyway. Effective civil legal services and protect eligible clients.
That's what it was, protect.
Yeah. Well, and protect is there, so I was just trying to find a place for add that sentence. And then the last point I was making sort of follows after that. It says, starts with to be approved by the commission. And I don't know that I guess a part of what we're doing is approving the quality controls, but the commission's role, I think, goes further, because one of my questions under the sort of due process, the procedures piece is who's making the decision to take action against someone, and what is the process by which that happens? So I think the commission's role might be in, reviewing the quality control, but also in these other areas. And I don't think staff should, with all due respect to staff, because I think they give us good advice about these things, but I don't think staff would even say they should be the one to suspend a program, that it should come to the commission, and we should be clear about that.
And on the due process, Raul can go, because there is a state bar rule, 3691, that deals with terminations. If it would be more clear to everybody, because it seems like maybe a source of confusion, we can refer back there, but maybe Raul can describe what that is. But yeah, I agree with you. If it's a termination, if something that affects eligibility, I mean, that's a very high standard, and us, the staff, do not want it to affect the staff. I would not support that either. So I think it needs to come to the larger commission, and there is a process for that. So I do want to note that Raul is ready to describe that, and then Jennifer can address the fiscal controls issue, your concern about that. But I agree with adding the civil legal services. I think that's a really great suggestion. So patience whenever you're ready for Raul and Jennifer to address those two things.
That would be great. Thank you.
So maybe Raul, would you want to go
Oh,
first?
wait, Jason had another
I'm
comment.
sorry. And I'm sorry,
Yeah.
Catherine and I can't see the hand raised, so
I'm
we
actually fine if
apologize.
we take the document off,
Oh,
because
yeah,
I
could
have
you-
the document, and then we can.
Jennifer, yeah, could you, so then we can
There.
see.
Oh,
Okay,
yes,
perfect.
Patience is
Yeah,
so
yeah,
big.
Perfect, okay.
We're like sitting in your office now, Patience.
I'm sorry, I didn't catch that last.
Oh, I was just joking and saying we now can see you, and it looks like we're just sitting in your office with you.
There you go. Very comfy. Jason, did you want to make another comment?
Yeah, just because we're going to talk about the due process piece, so I just want to kind of clarify one thing. Yeah, I don't know that it's necessarily just terminating a grant. I think creating an avenue in our rule set or procedure that gives the recipient an opportunity to tell their side of the story for commission consideration. When there are going to be consequences that affect the grant amounts, or whether they're doing reimbursements instead of advance payment, all that stuff of, maybe there should be tiers, of this significance, it goes through this due process step and there's tiers or whatever, depending on the gravity of the potential consequence. But it seems to me that the commission should be able to hear from either in direct, communication, or to read a response to the concerns from the entity themselves, an explanation, so that we can make a decision informed by and contextualized by their perspective, because some of these things could be misunderstandings. And I don't think the commission would want to be making a decision absent that information.
So Jason, I agree with you. I think it's like before the commission takes any action, because it could be, we've kind of done this in eligibility and budget review, like we're going to send a letter off to your board, but if the program has something to say about why we're wrong, we want to know that at the front end, so it can factor into like, we agree or we disagree with what action we're going to take, right? So I just think that's a step back from the formal due process, I think that Raul was going to talk about under that state bar rule, but there's kind of two parts of that.
And I agree with that. I think we've been doing it, like there's an informal practice, because we haven't actually been doing something without the commission's approval. But I think we need to be clear what that is. And I would say there needs to be some type of line, because there are lots of actions. So what is actually like something that needs the commission, and then what is something that feels less substantive? I think, and I don't have an articulation for you all. I think we all feel it, but I think we need to articulate that so it's very clear.
So I think we're ready for Raul and Jennifer.
Raul is not in the attendees.
Oh,
pool.
could you maybe Jennifer can go while you promote Raul, and he can go after
Oh,
Jennifer.
he's not in the
He's not.
attendee pool. Would you like me to
Oh.
message him?
Yeah, can you promote him? He's Oh, he's not on,
Zoom.
he's
I
not
have to
on.
see him.
Oh, gotcha, I thought he was on, cause he's,
No.
okay.
So
I thought he was on. Okay.
I'll go ahead really briefly. And just in terms of the question about more specificity for financial management, we actually purposefully left it as is because there will be a fiscal codification topic that deals with that specifically. So we wanted to focus on more the program side of quality controls, but leave a space for those fiscal topics. So Duan, you can correct me if I'm wrong, but I believe the intention is that we will ultimately present this as part of the same rule, but again, they're just different codification working groups.
Yeah, so I know this feels a little bit kind of awkward. We had to have a dividing line because it was too much for one staff to take on all of this. So we decided Jennifer's working group would deal with like kind of the program, and then Heidi's would, and then we eventually, when we send it out, it would be sent out as a package. I know that makes it a little bit like.
But I think we should just say placeholder for
Yeah.
fiscal controls rather than, because it looks
has
like
the
when it's
impression.
sent out, it gives the
Yeah.
impression of like,
Okay.
you've actually decided something.
Gotcha,
So
gotcha.
I think the
Yeah.
first sentence is fine, and then just put placeholder because the examples are gonna be
Okay.
more robust than that, I think.
Okay, yeah, that's easy enough to do because your instinct is right, and that the fiscal, there's a lot of stuff that needs to
I'm
be
sure
really
Heidi
clear.
did not
Yeah.
look at this
No.
when I got to
Yeah.
that, so now I understand why.
Yeah.
So this isn't the first time that we've left a space for cross-reference to a codified policy that doesn't exist yet. So, and I do understand that at some point, these are basically gonna all be rolled up together and presented to the state bar the trustees as a package, as a whole.
I mean, it's not all of it is not gonna package, but to the extent we can, so like internal controls and fiscal controls will be packaged together because it makes sense. So, and also like support centers, there's like 2 working groups, but they will eventually be packaged together. So the extent we can will be packaged together, but we're not gonna package everything together.
Yeah, but the topics that are aligned will be packaged together.
Exactly. It's just, it was too difficult to wait like a year to do it, so we're doing it piecemeal.
So, for our purposes right now, the financial control section can have a little, like between brackets, it says, and please see, X, rule X, which addresses these, or which is more specific about them, or something like that. I mean, is that, Catherine, would you
I think it's gonna ultimately be in this same rule, it sounds like.
Yeah.
So it's really, however we wanna say it, it's like, that helped me a lot to say,
Yeah.
like, we're actually not suggesting this is all you would need.
Yeah.
So I just called it, but fine, this is a placeholder for what's to come, and this isn't gonna go anywhere till that other work is done.
Exactly.
Right, perfect, okay.
And then I know Raul is hopping on right now, sorry, I thought he had been on, because him and I have been teamsing, and he can go over the rule 3691 when he hops on, but we can also then draft a suggestion, we won't be able to draft it on the spot, that addresses Jason's feedback, because I think we need to dwell on that a little bit and see where the line is for what goes up to the commission. I think we have a sense, but like I said, I'm having a hard time right now articulating it.
Hi, Duan, I'm on the call now.
Hi, Earl, just to catch you up to speed, so there was a question about due process, and I know we have a rule that maybe you can describe about termination, but Jason made the really good point of, it's not just about due process in terms of termination, but something that's like substantive or important feels like then the commission, and we do this informally, I agree that we probably need it codified in terms of what it is that goes to the commission, maybe what it is that stops at the committee, and what it is that staff. And having and I said that I don't think we could do that now on the fly, but perhaps we can work outside of this meeting to then bring that piece back to the committee. But maybe you could start with describing 3691 for us, what the due process in terms of termination. And if you can recall, I don't think there is another rule in terms of other due process for other non-termination, I guess, serious issues.
Yeah, that's right. So Rule 3691 doesn't cover just like termination, it's also for like the denial of funding or like refusing to renew funding. But essentially the procedure provides that this consideration goes before the commission if an applicant challenges that determination. And then so there's a process by which that person has like time to like provide additional information to contest that determination. And then there's further time provided for the commission to decide whether or not it's going to affirm or modify or reverse its decision. So there's a timeline provided by the rules for that, and ultimately, if the person still wants to challenge that decision, they can go to the state bar court. So that's the due process that we provide, which is likely appropriate given the sanction in that case, which would be denial or termination. You know, if we decide to take steps that are less severe than termination, you know, I do think it makes sense that we might have a different level of process.
So what about a denial of initial eligibility? Is that the same or not?
That triggers 3691, right? Raul, like.
I guess I'm just trying to
applicant-
understand the scope
Yeah.
of what's in and what's out, because that starts helping define what due process looks like, right?
The rule covers a denial of an application for initial funding.
Okay,
So that seems that would cover that.
okay.
So that's like IELTS to EF, like we're in the midst right now. So we get a new applicant or a returning applicant, that falls under that. What this doesn't cover, just so everybody's clear, like RFP, Raul, correct me, like if a commission makes an award for, say, a competitive grant, I know we have in our application, like all decisions are final. That's not appealable, right? Like
No, I mean, I do think this rule is governed to, sorry, it's limited to these situations, and there's not otherwise a procedure in place as of now.
But you could, if that's something you want to build it. It's hard though for competitive because, you know, we've already distributed the money. But then I think there's what Jason, this is what you miss, Raul. Like, what about like, you know, we had an issue where we converted like grant payments from like, I think semi-annual to monthly. Like in those situations, I do think the committee or the commission needs to approve. I don't know whether it was the committee or the commission, but it probably should not be at the staff level. But I don't think we have a rule now. We do that because like that's based on, I think, instinct that we feel like the commission would want to, but we don't have a rule around stuff like that, right? That feels a little bit more, I don't know, serious.
Yeah.
Yeah,
So-
and I think that's up for the commission to determine if they feel that that's a sort of severe enough or significant enough consequence that we should have due process procedures in place for that.
So it like in a in the HP funding, those were multi-year,
Yep.
right?
Mhm.
And so so I appreciate it's discretionary at the front end, but now you're gonna terminate it midway
Yes.
through. And where does that fall in this construct?
Oh, that's a good question, Raul. My understanding that would fall under 3691 if you terminate any rule, but are you saying that's just 3691 is just IELTS and EF? And we need to make it maybe more, yeah, that's a good hypothetical.
Federal funds require, termination federal funds require us to also follow our own procedures. So 3691 would also apply for federal funds that are non-IELTS and non-EF.
So we were considering like terminating at Catherine's example, an HP midway, it would trigger 3691, right? We'd have to bring it all the way up to the commission, and then if the grantee contests, then they have those appeal kind of mechanisms.
Yeah, that's right.
So I do remember we had a long conversation. Now I'm not even remembering the specifics, but I do remember we talked about situations under which the commission may put a grantee on a monthly payment schedule or a reimbursement rather than advancing funds, or those kinds of not denial of funds, not withdrawal of funds, but making the funds more contingent on performance and kind of keeping a closer eye. And I see Jason's on the camera now. I don't know if he's still with us, but I'm just curious whether or not it's that kind of, or Catherine, would you think that kind of decision would be should trigger some kind of additional due process?
Well, and I guess to me, like due process can be flexible. I mean, this idea that you could go to the state bar court because somebody decided you had to seek monthly reimbursements. I'm not sure that I would say that went there. But does that mean there should be the opportunity to be heard before the commission as a whole makes the final decision? Probably, right? Like, I think that's why I think kind of figuring out what the action is and what does due process look like for the different actions that could be taken. I mean, the example I have, it's like we were requiring someone to repay funds, as I recollect, in a HP case. And we were told that I think, that there was no appeal right at all from that, like that's just what they had to do. So I think it's sort of listing out all those examples that have occurred over the years and figuring out like, yes, that makes sense how we did it before, or no, there should be the opportunity to be heard, and like who makes the final decision. So it's almost just like using examples to help inform what does due process look like, given the various list of proposed actions that we could take.
So what's the sense of the body about what to do about this due process question?
I think we need a little more work. And Jason's back.
And let me ask you this for the whole committee. Do you think, I agree you need work, but do you think that can be isolated, or do you think you need work and it's to weigh off, like the package for this?
That we should,
I think it needs work. I don't know that I think there's tweaks that we've talked about, but I think the section that feels the least clear to me is just there's a list of actions that the commission can take, but it doesn't necessarily describe when does rule 3.69 or whatever the rule number is go into effect, and should it affect other ones, maybe yes or no, and if it doesn't affect those, what are the concrete steps we're going to take? So I just think that has to be written out in a way that's understandable to commission members, but also to grantees.
Sure. Sorry, Jason.
Jason, did you?
Thank you. And to be clear, I haven't left anywhere. I'm just off camera. I'm still here. I'm listening. So I think the big thing for me in all of this is that somewhere that specifies that in these circumstances, that any of these negative consequences, that the grantee will be given, or that the organization will be given an opportunity to be heard prior to the determination of any of these negative consequences. Right. And that's the most fundamental of fundamental due process things. Like, we're not just going to unilaterally decide without giving you an opportunity to explain yourself or rationalize or give greater context. Right. So what that and how that opportunity to be heard manifests is an open question. And I can be very open-minded about how we do that, and whether, is it before the commission? Is it a hearing? Is it a letter? Whatever. But to me, what's important is that we make room and we make space in our rule structure and our procedure for an opportunity to be heard. It might just be for like staff has identified this, and again, to Dwan's point earlier, that she was saying, like, I'm sure this is happening already, right? The staff reaches out and say, like, what's going on with this? Explain this to us, whatever, right? We're leaning towards this because we're concerned about this, that, and the other thing. An opportunity to be heard, to explain, justify, rationalize, connect it to the rules, so that it's not just arbitrary and unilateral decision making by either the commission or state bar staff. And so long as we have that codified somewhere, right, I think to me, that's the big important piece. And while I think that is in practice happening, at least I understand it to be happening, somewhere in the rule, I think, might clarify that we're not going to do this without, so that if someone's looking at the rules, like, well, what do I do? How do I make sure that my perspective is being considered? It's codified and contemplated somewhere that we're going to do that.
Okay, Vanetta,
Thank you. Wonderful conversation. I need, I want to make one point, but then I have a question for myself as a new learner. Um, it sounds like what's missing is a dispute resolution process. In other words, when there are disagreements or lack of clarity, what's the procedure so that all parties, all stakeholders are, are considered? That's what this process discussion kind of sounds like to me. I think the other thing is, I don't know what a state bar court is. Can somebody explain that?
Oh, that's a great question. Raul, you want to take that one? What state bar court is?
Sure. So the state bar has its own adjudicative administrative body. So this is normally the court that handles all the discipline procedures. So they're the body that adjudicates attorney discipline, essentially on behalf of the California Supreme Court. But they're also provided by like various rules can hear other disputes involving the state bar, such as, for example, something that would come under Rule 3.691.
Okay, so in other words, if a grantee had some concerns and they didn't feel like there was adequate resolution, if we had a dispute resolution process that was still unresolved, then it would go to the state bar court.
Yeah. I mean,
But
the
not
other,
everything.
not everything. The other thing that I would do want to note that, and maybe Raul can touch on this. I mean, the applicant or grantee can also go file in Superior Court. That doesn't preclude that. State bar court is a clear kind of pathway to an appeal, but that's always available to them, right? Raul, that's my understanding.
Okay, all right. Thank you.
okay, so it sounds like, oh, you have your work cut out for you about inventing the language that will satisfy Jason and the rest of us really about a kind of second tier or less than, if it's something less than the nuclear option that's being exercised, then there still needs to be people to be heard and before the adverse consequences are imposed. So that leaves the financial controls and the language changes that Catherine was looking at, or the legal services definition and taking out protect and ensuring that better specificity about what the mission is of the grantees using this money. How do we want to handle the financial controls?
Can I make a suggestion? Because I think what I'm hearing is that we probably should package it kind of together because that's substantive, the due process. So the fiscal working group is working on that and they're going to bring it to you all in September, that working group. Heidi, correct me if I'm wrong on that. Jason is actually on that working group too, and Raul is helping us as the OGC attorney on that. So we can package this together with the two teams can work together and then we can come back to you with this again, Catherine's suggestions for the language, the due process of state bar rule around that, and then you can see how it's all laid out with the fiscal internal controls kind of requirement. Heidi, let me know if I'm wrong on the timeline, but I think that your working group is going September around those issues, and then that would just be nicely, we can just do all that and then bring it as a bigger package in September.
Wait. I thought I was providing feedback. I didn't realize I was volunteering too.
It does impact your working group, the fiscal, so we'll just run it by you to see if like we're missing anything. Because you have to do it for, it's both, right? Fiscal and program, so whatever we think is the line for substantive, and we'll have to, Raul and I will noodle on what that means, Brady too, and bring it back. But so just so before it comes to the working group, it's hard, right, to wordsmith in a committee, so if you don't mind, we can pick your brain.
I don't mind, I'm giving you a hard time, that's all, thank you.
And I think here, like right now, it's sort of just a laundry list of things you might do, and they're not even necessarily in the order of where you might start, right?
Yeah.
And so figuring out like, what level of, like Jason's point, you always get the basic opportunity to be heard. But what happens after that, depending on what's happening, might vary, and think about some groupings of those from least serious to most serious, right? Like a letter to the, we're now proposing that we're gonna send a letter to the board, like fine, you should be heard to make sure we got the facts right, but we're not gonna give you a hearing because we're sending a letter to your board. That makes no sense, right? And on the other hand, you're gonna lose your money. Well, we already have a state bar rule for that. And then there's a bunch of things in between that we might want to figure out, what does that look like? And you know, that would be great if somebody can do that, and then it'll come back here again.
Yeah.
And I can send, if it's helpful, I can just do line edits
Oh,
and a
yeah,
little
that'd be
email
wonderful.
for the other things that I was
Perfect.
raising.
That'd be great.
Thank you.
That's great, great discussion.
Anything else? Yes, Chuck.
Yes, I just want to add that on behalf of the entire our working group, I really appreciate all of the good feedback and information that everyone has provided. It's really helpful to me, especially as a new commissioner. So I really appreciate all the thought and look forward to continuing to work on this with the rest of the team members to address all of everyone's concerns. They all sound very legitimate to me.
Well, and thanks for taking the lead on this. How about that? Complicated topic.
Thank you and your work group for bringing us this really significant improvement.
Hmm.
Thanks for being so gracious about the critique.
Yeah, yeah, sure, no problem. I'm a new commissioner, so it's all good for me. It's a learning process in the works all the time, so ongoing. So I appreciate it, all of the concerns.
Thanks. Anything else? Going once, going twice. In that case, do I have a motion to adjourn?
So moved.
Thank you. We got to the one. Is there a second?
I'll second.
Thank you. All in favor? We do not have to do roll call for this one. Thank you.
Right.
Favor?
Aye.
All right. Have a wonderful rest of
Aye,
your
thank
day.
you.
everyone.
Thank
Okay.
you.
Thank you so much.